Sharing in the Novo Banco appeals.
Yes, good morning, Mr. Lewin.
May it please the Court, I appear for the appellants in Appeal 2016-0215 with Mr. Kaplan and Mr. Venkatasan. My learned friend, Mr. Lord QC, appears for the appellants in Appeal number 2016-214 with Mr. Pluman QC and Mr. Schaffer. My learned friends, Mr. Salter QC and Mr. Phillips, appear for the respondent in both appeals, Novo Banco. And my learned friends, Mr. Howard QC and Mr. Jones, appear for the intervener, the Bank of Portugal, which we have referred to as the BDP. As the Court knows, this appeal concerns a dispute about whether the English Court has jurisdiction over a debt claim which my clients in GSI, Goldman Sachs, have brought in the English courts against Novo Banco, a Portuguese company, for a sum of in excess of $800 million. We say that the $800 million is owed to us under a contract, the facility agreement, which is both governed by English law and contains an English jurisdiction agreement. We say that Novo Banco became a party to the facility agreement in August 2014 as a result of measures taken by the BDP, the Portuguese Central Bank, replacing the original counterparty to that agreement, a Portuguese bank known as Banco Espírito Santo, which had come into financial difficulties. And as the Court will have picked up, whether Novo Banco became a party to the facility agreement in August 2014, and whether it remained a party to that agreement thereafter, is the key issue that arises in relation to the jurisdiction dispute between the parties. And at its heart, this is an issue that turns on what is, in essence, a factual question. Namely, whether the Oak liability was an excluded liability as defined in the August decision, it being common ground that the Oak liability would indeed have been transferred to Novo Banco by reason of that decision, unless, that is, it was an excluded liability. And what is perhaps a striking feature in this case, as the matter comes before this Court, is that on this essentially factual question as to whether the Oak liability was an excluded liability, it is not disputed that based on the evidence before the English Court, the appellants have the better of the argument. That is to say that the Oak liability is not an excluded liability, and that looking at the August decision alone, the Oak liability was transferred to Novo Banco, so that Novo Banco did become a party to the facility agreement in August 2014. That is what Mr. Justice Hamlin found, and that finding is not challenged before this Court. However, despite accepting that the appellants have the better of the argument in relation to this essentially factual question as to whether the Oak liability was transferred to Novo Banco in August 2014, Novo Banco and BDP as interveners seek to contend that this conclusion must be wholly disregarded by the English Court, and they do so before this Court solely by reliance on a later administrative decision made by the BDP in December 2014 in relation to the same essentially factual question, namely whether or not the Oak liability is an excluded liability in the context of the August decision. It is common ground, as the Court will have seen, that since the facility agreement is governed by English law, decisions of foreign administrative authorities, such as the December decision made by the BDP, can in fact have no effect whatever on the identity or the rights or obligations of parties to that agreement, save to the extent that such foreign administrative decisions, for whatever reason, fall to be recognized as effective in English law. And that, of course, raises the central issue for determination by this Court, namely whether this decision by the BDP in December 2014 is a decision that does fall to be recognized as effective by the English Court. As the Court will know, Novo Banco and the BDP rely on two European directives which they say oblige the English Court to accept the December decision as effective under English law, namely what the parties have been calling the Reorganisation Directive of 2001 and a later directive, the EBRRD of 2014. And those directives, according to Novo Banco and the BDP, bind the English Court to give effect to the BDP's December administrative decision, and they say that this is so even if the English Court is satisfied that this decision will in due course be overturned in Portugal as well, itself. the court will have seen from the written cases that Novo Banco and the BDP contend that there are two different routes by which the December decision falls to be recognised as a matter of English law. They say first that the December decision is in its own right what is known as a reorganisation measure under the European directives I mentioned a moment ago, and must for this reason be recognised in English law. And they say alternatively that even if the December decision is not a reorganisation measure in its own right, since that decision, they say, determines the effect of the earlier August decision has under Portuguese law, and since it is common ground that the August decision is a reorganisation measure in its own right, it follows, they say, that the English court must give the August decision whatever effect the December decision says it has. As the court will appreciate, the first route, which in our written case we describe as issue 1, is about whether the December decision should be recognised directly as a reorganisation measure in its own right. And the second route, which in our written case we describe as issue 2, is about whether the December decision should be recognised indirectly as something which determines the effect of the August decision, even though it, the December decision, is not in its own right a reorganisation measure. And that in broad outline, my lady, my lords, is what the dispute before this court is about. In terms of my submissions, subject to the court, what I propose to do is to first show the court very briefly the relevant regulations and directives which lie at the centre of this case, as well as the 3 decisions by the BDP which are relevant to your ladyship's consideration. And then, having done that, to address first issue 1, the direct recognition argument, and secondly, issue 2, the indirect recognition argument, in that order. So against that background, can I then say something about the legislative scheme? And I'm going to take this relatively quickly because, as the court knows, this is set out in the Court of Appeal judgment itself between paragraphs 5 and 15, core 2, tab 14, page 397. There are essentially 3 parts to the legislative scheme of which the court needs to be aware. First, there is the English regulation by which reorganisations are given effect in English law. It's the law in England which says give effect to these Portuguese administrative decisions, and indeed the administrative decisions of any other member state. That is contained in the 2004 regulations, which have been amended by an order in 2014. Then there are the 2 European directives. First, the Reorganisation Directive, and then the EBRRD. And perhaps I can just show the court those 3 bits of legislation. First, the 2014 regulations. The court has those at Authorities Volume 1, tab 3, page 1391. And as the court sees, this is the 2004 regulation, the Credit Institutions Reorganisation Winding Up Regulation. If I can invite the court, please, to go to page 1397, where we have Regulation 5. An EEA insolvency measure has effect in the United Kingdom in relation to and C is what we're concerned about, any debt or liability of that credit institution as if it were part of the general law of insolvency of the United Kingdom. So if you have an EEE insolvency measure, it has an effect in the United Kingdom in relation to a debt or liability as if it were part of the general law of insolvency of the United Kingdom. And so far as I understand it, none of the parties think that anything turns on the reference to the law of insolvency. We have all proceeded on the basis where it says the general law, it means the general law, not just of insolvency. EEA is a defined term, and the court will find the definition of EEA insolvency measure. If you go over the page, it's in subparagraph 6 of Regulation 5, top of the page. EEA insolvency measure means, as the case may be, a directive reorganisation measure, and the court may want to note that that is a defined term, or directive winding up proceedings, which have effect in relation to an EEA credit institution by virtue of the law of the relevant EEA state. And then in terms of what is a directive reorganisation measure, Can I invite the court, please, to go back to Regulation 2 in this regulation? That's at page 1393. Towards the top of the page, the court sees directive reorganisation measure means a reorganisation measure as defined in Article 2 of the Reorganisation and Winding Up Directive, which was adopted or imposed on or after the 5th of May 2014. Just in terms of 2004, Reorganisation Winding Up Directive one sees defined over the page at 1394. And that is the 2001 directive that I'll take the court to in a moment. Just pausing there, what one therefore has is Regulation 5, which says insolvency measures are to be regarded as part of the general law of the United Kingdom. Insolvency measures are or include directive reorganisation measures. If you go to the definition of directive reorganisation measures, that means a reorganisation measure as defined in Article 2 of the 2001 directive. Now, I'm going to take the court to the 2001 directive in order to show the court how a reorganisation measure is defined. Before I do that, I need to tell the court that this definition of directive reorganisation measure here was amended by the Bank Recovery and Resolution Order with effect from 10th of January 2015, and perhaps I can just very quickly show that to the court. That is in Authorities Volume 2, behind tab 9, page 1562. So we have the Bank Recovery and Resolution number 2, Order 2014. And just if I can invite the court to look at paragraph 1, subparagraph 2, this order, except part 9, comes into force on the 10th of January 2015. And then if I can invite the court next to go to Schedule 3, Part 3, paragraph 10 on page 1672. The court sees paragraph 10 to C towards the top of page 1672.
Sorry, could you just wait a minute? I'm just...
Sorry.
There seems to be something wrong with it. Right, sorry, where were you?
You can get 1672. 1562 isn't coming up on our...
Oh.
1672.
The passage to which
Yes, right.
sort of minutes is very can
Right,
come
but
up.
1672, right.
Yeah.
Yeah,
Just so the court sees, this is amending the definition we just saw in the English regulation for the definition of directive reorganisation measure. Substitute directive reorganisation measure means a reorganisation measure as defined in Article 2 of the Reorganisation Winding Up Directive, which was adopted or imposed on or after the 5th of May. That's what it had always said up till this point.
Then there's the added...
Then you have the or any other measure to be given effect in or under the law of the United Kingdom pursuant to Article 66 of the Recovery and Resolution Directive, and that is the EBRRD, and I'll show the court that in a moment. So that's the English regulation, in effect saying if it's a directive reorganisation measure as defined in Article 2 of the reorganisation measure, then it's to be given legal effect, and it is also to be given a legal effect if it is a measure to be given effect in or under the law of the United Kingdom pursuant to Article 66 of the EBRRD. And the court will appreciate that these definitions are important because if the December decision is to be recognised in English law, then the primary case which is being advanced by my learned friends is that it is to be recognised as a reorganisation measure, and that means it either will have to come within Article 2 of the Resolution Directive, Reorganisation Directive, or it will have to fall within the reference to Article 66 of the EBRRD. Can I then just invite the court to go to the 2001 directive, that's the Reorganisation Directive. That is in Authorities Bundle 1, Tab 1, which you may still have available. And if I can begin by showing the court Article 2, which is the definition section, beginning at 1225. Bottom of page 1225, Article 2 definitions, the court sees reorganisation measures. They're defined. Reorganisation measures shall mean measures which are intended to preserve or restore the financial situation of a credit institution and which could affect third parties' pre-existing rights, including measures involving the possibility of a suspension of payments, suspension of enforcement measures, or reduction of claims. So to come within Regulation 5 under this head, as the court sees, it has to be a measure which is intended to preserve or restore the financial situation of a credit institution, and so on. Now, as if that weren't sufficiently complicated, I need to tell the court that this definition was itself amended by a provision in the EBRRD, that is to say Article 117 of the EBRRD, and if I can invite the court just to go over to tab 2, where we have the EBRD, and you will find Article 117 at page 1379. It begins at page 1378. And so Article 117 starts at the top of the page, and then if your lordships and your ladyship go to subparagraph 2, about two-thirds of the way down, one sees Article 2 is replaced by the following definitions, and then over the page, reorganisation measure shall mean measures which are intended to preserve or restore the financial situation of a credit institution or investment firm as defined in Article 4.1.2 of Regulation 2013, and which could affect third parties' pre-existing rights, including measures involving the possibility of suspension of payments, suspension of enforcement measures, or reduction of claims. Those measures include the application of the resolution tools and the exercise of resolution powers provided for in Directive 2014. And so again, just standing back, Regulation 5, which is the provision which says certain things which are happening within European member states have to be given effect as if part of English law, refers to Article 2. I've shown the court Article 2. It's now amended by Article 117. And again, Regulation 5, the definition there was itself amended, as I showed the court, by the Order of 2014. And that is how one gets to the scope of the reorganisation measures which are relevant to this case. And perhaps just before I show you the court any other provisions in the EBRD or indeed the reorganisation measure directive, I ought just to identify the three potential gateway reorganisation measures which are relevant to this case. And I'll come back and develop my submissions on this in a moment. But there are three ways.
Just to get it straight, that's a sub-definition, effectively, which feeds into the earlier
Article 2, which feeds into Regulation 5.
Yes. Right.
Now, all of that leads to a definition of reorganisation measure which includes the following three gateways. The first gateway is one which derives from the original definition of reorganisation measure in Article 2 of the Reorganisation Directive, and that is to say, is it a measure which is intended to preserve or restore the financial situation of a credit institution, and so on. The second gateway, to which this gives rise for relevant purposes, arises from the reference to those measures include the application of resolution tools and the exercise of resolution powers provided for in the EBRD. So number one, was it a measure which was intended to preserve or restore the financial situation of a credit institution? Number two, is it a measure which is one of those relating to the application of the resolution tools and the exercise of resolution powers provided for in the EBRD? And the third, and this goes back to the amendment to Regulation 5, which we saw brought about by the order of 2014 relates to whether it's a measure to which effect has to be given by virtue of Article 66 of the EBRD, and that's in effect transfers. Article 66 is a provision relating to transfers. And just in case the court is lost, and I can see why that might happen, I should note that the three gateways I've identified are all identified in our written case at paragraph 36, Core Volume 1, Tab 9, page 184. Now, I had shown the court the Article 2 in the Reorganisation Directive. Can I just show the court one other provision in the Reorganisation Directive which is going to be occupying a fair amount of the time of this court, and that is Article 3, Authorities Bundle 1, Tab 1, page 1226. The court sees the heading here, Adoption of Reorganisation Measures, Applicable Law.
Sorry, can you give me that reference again?
Sorry, page 1226 of Authority Bundle 1, behind Tab 1. Adoption of reorganisation measures, applicable law. The administrative or judicial authorities of the home member state shall alone be empowered to decide on the implementation of one or more reorganisation measures in a credit institution, including branches established in other member states. The reorganisation measure shall be applied in accordance with the laws, regulations and procedures applicable to the home member state, unless otherwise provided in this directive. They shall be fully effective in accordance with the legislation of that member state throughout the community without any further formalities, including as against third parties in other member states, even where the rules of the host member state applicable to them do not provide for such measures or make their implementation subject to conditions which are not fulfilled. Just pausing there, my lady, my lords. Article 3, the court will recall that in my introduction I identified two methods by which Novo Banco seeks to contend that administrative decisions made by the Portuguese Central Bank have to be recognised as effective in English law. There was the direct method and the indirect method. Now, the direct method, again, having shown the court the definitions, relates to an attempt by Novo Banco to say that the December decision was in fact a reorganisation measure within the definitions I've shown you, and there are three gateways by reference to which they say that. That's the direct route, that is issue 1. Article 3 is relevant to issue 2, which is the attempt by Novo Banco to say that the decision by the Portuguese administrative body, the Bank of Portugal, should be given indirect effect in English law, because they say the December decision in effect defines or tells one what effect the August decision is to be given in English law. And just to unpack that a little bit, it is common ground that the August decision is a reorganisation measure. So it is common ground that the August decision is one which is effective in English law. The debate is all about, as I said in opening, the December decision. What is being said by my learned friends by way of the attempt to ensure that the December decision gets recognised in English law, albeit indirectly, is that the December decision, in effect, tells the court, is the way in which Portuguese law gives effect to or implements the August decision. And because they say the December decision is the way in which Portuguese law implements the August decision, they say it needs to be given effect indirectly by virtue of Article 3, subparagraph 2.
Is it very indirect? It amounts to saying that the August decision is one which is subject to administrative amendment under Portuguese law, isn't it?
That may be well, Effectively, what this...
fully effective in accordance with the legislation of the member state.
Indeed.
And they say Portuguese law has administrative procedures for tinkering with, they would put it, or altering. You would say it's fundamental. A reorganisation measure.
Well, I think what is not in dispute is that if it's a reorganisation measure, it needs to be recognised. Issue 2, the indirect route, arises on the premise that they do not succeed in persuading the court that the December decision is a reorganisation measure. What they then say is that notwithstanding that it's not a reorganisation measure, because it is the way in which the August decision is implemented, it needs to be given effect as being the implementation of the August decision. Now that gives rise to the three issues that arise under issue 2.
I mean, somebody has said, I forget who, that the issue really could be seen the other way around.
We do say that, and that, of course, is the way the Court of Appeal has
Yes.
approached it. You'll remember the Court of Appeal, the majority, said you never get to what Mr.
Yes.
Rabinowitz is describing as issue 1. And indeed, our primary case, and BDP's position, is it's what Mr. Rabinowitz is calling issue 2 is actually the real issue. And if we're right about that, you don't get to what Mr. Rabinowitz is describing as issue 1, and he's doing that for forensic.
You don't have to worry where it has the higher status of itself being a reorganisation measure, because it's simply the August measure you're looking at as interpreted by the Portuguese administrative authority.
My Lord, it doesn't really matter which way around
No.
I'm doing it. I'm doing it because one has to get one's head around what are
Right. No, you're putting it
reorganisation
very
is
helpfully.
before you look at Article 3 to decide whether something is the way in which Portuguese law gives effect to reorganisation. And in our respectful submission, that is the logical way to do it. The court, my learned friend is right, I don't run away from that. The Court of Appeal decided on the second ground is what appears to be their primary ground. And I'm not running away from that at all. It's just, in my respectful submission, the easier way to understand this is by working out what are reorganisation measures, how does this work, and then coming to the question of whether, if they can't get the December decision in as a reorganisation measure, can they get it in by saying it is in effect the way in which Portuguese law gives effect to the August decision. There is no forensic, other than an attempt to be clear, there is no secret forensic purpose behind this. Can I I've shown your Lordship and your Ladyship some definitions. Can I just take you back to the EBRD behind tab 2, just to show the Court one or two other definitions before I develop my submissions. Article 1 of the EBRD, and it may just be worth having a look at the heading for this. It's the 2014 directive, establishing a framework for the recovery and resolution of credit institution investment firms and amending council directive, various council directives. If I can then invite the court to go in the EBRD.
Where were you reading then?
I was just reading the heading on page 1232.
Oh, I see, yes. Thanks,
If I can then invite the court to go to page 1253, just to identify for the court Article 1, which sets out the subject matter and scope of this directive. Nothing turns on this, and I'm not going to spend time showing the court this, but the court sees this directive lays down rules and procedures relating to the recovery and resolution of the following entities, institutions that are established in the union and the like. Can I invite the court next to look at some important definitions in Article 2, and in particular at subparagraphs 19 and 20 of Article 2, which we have at page 1255. These are the definitions of resolution tool and resolution power. So subparagraph 19, resolution tool means a resolution tool referred to in Article 37(3). And if I can just show the court 37(3), that's at page 1298. The court is at 1298, Article 37. Member States shall ensure that the resolution authorities have the necessary powers to apply the resolution tools to institutions and to entities referred to in points B, C, or D of Article 1 that meet the applicable conditions for resolution. And then it's subparagraph 3, the resolution tools referred to in paragraph 1 of the following: 1, the sale of business tool; B, the bridge institution tool; C, the asset separation tool; D, the bail-in tool. And we are concerned with the use of the bridge institution tool, which is B. And whilst at this part of the EBRD, can I invite the court to go over the page to Article 40. It's in fact over a few pages. It's page 1303. The bridge institution tool, Article 40, 1, in order to give effect to the bridge institution tool and having regard to the need to maintain critical functions in the bridge institution, Member States shall ensure that the resolution authorities have the power to transfer to a bridge institution A, shares or other ownership; B, all or any assets, rights or liabilities of one or more institutions under resolution. And obviously we are concerned here with B, because the issue here is whether there was a transfer of the Oak liability. Subject to Article 85, the transfer referred to in the first subparagraph may take place without obtaining the consent of shareholders of the institution under resolution or any third party other than the bridge institution, and without complying with any procedural requirements under company securities law. And then 2, the bridge institution shall be a legal person that meets all of the following requirements. I don't think the court needs to be concerned with those. Can I show the court paragraph 5 on the top of page 1304? When applying the bridge institution tool, the resolution authority may exercise the transfer power more than once in order to make supplemental transfers of shares or other instruments of ownership issued by an institution under resolution, or as the case may be, assets, rights or liabilities of the institution under resolution. Just pausing there and standing back, what this effectively enables member states to do with a financial company in trouble is to set up a new separate institution, a bridge company, effectively a good bank, so that you can transfer assets, liability, shares from the bad bank to the good bank as a way of protecting the financial system of the member state. So paragraph 1 gives the general power to make transfers. Paragraph 5, which I showed the court, enables the state or the resolution authority to make supplemental transfers. In other words, it's not a one-off shot, and there is a specific power to identify additional transfers which the resolution institution may wish to make. Then paragraph 6, following an application of the bridge institution tool, the resolution authority may A, transfer rights, assets or liabilities back from the bridge institution to the institution under resolution, or the shares or other instruments of ownership back to their original owners, and the institution under resolution or original owner shall be obliged to take back any such assets, rights or liabilities, or shares or other instruments of ownership, provided that the conditions laid down in paragraph 7 are met. And then B, transfer shares or other instruments of ownership or assets, rights or liabilities from the bridge institutions to a third party. So both a power to transfer onto a third party and as well as a power to transfer back to what one might call as the institution under resolution, the bad bank, if you like, the bank which is in financial trouble. So it has the power to transfer both on and back. That is subject, as it says, to certain conditions, which are the conditions laid down in condition 7. Resolution authorities may transfer shares or other instruments of ownership or assets, rights or liabilities back from the bridge institution in one of the following circumstances. A, the possibility that the specific shares or other instruments of ownership, assets, rights or liabilities might be transferred back is stated expressly in the instrument by which the transfer was made. B, the specific share or other instruments of ownership, assets, rights or liabilities do not in fact fall within the classes of or meet the conditions for transfer of shares or other instruments of ownership, assets, rights or liabilities specified in the instrument by which the transfer was made. Such a transfer back may be made within any period and shall comply with any other conditions stated in the instrument for the relevant purposes.
B is a rather interesting concept.
Indeed.
Because basically it's saying that the transfer should not have taken effect or did not take effect at all. So it's using the word transfer in a rather odd way, because they're saying the rules for the transfer were that certain assets should go across. These assets do not come within the definition therefore they're being retransferred. Another way of looking at it is saying they never went across.
Well, with respect, this is one of the issues that arises. And
Yes.
of course, it depends on how they were transferred in the first place. If they were transferred specifically on the basis that they fell within a defined class,
Yes.
then they would have been transferred.
Yes.
And then they would need to be retransferred back. So, my learned friend, as my Lord knows, Mr. Salter has an argument which suggests that this doesn't make any sense at all. In our respectful submission, that was, of course, rejected by Mr. Justice Hamlin, and rightly so. This makes perfect sense because it caters for the situation in which there is a transfer of specific assets on the basis that they fell within a particular class. It is then discovered that they didn't fall within the particular class, but they have nonetheless been transferred because they were specifically transferred. And this enables or identifies the circumstance in which you can transfer them back.
Yes.
At this stage, all I want to bring to the attention of the court is that there is a power to transfer, there is a power to retransfer, but the power to retransfer is subject to certain conditions. It isn't just a free shot. We'd like to change things. It has to satisfy certain conditions.
Now, supposing the resolution authority maintains that it can operate the power to retransfer because it can satisfy both the conditions, does it have to show that it actually does satisfy those conditions for the retransfer to be valid?
In our respectful submission, yes, because it either has complied, it has exercised a power it has,
Yes.
or it hasn't.
Your
And if-
submission, as I understand it, your submission is not that Portuguese law can't make whatever
Indeed.
provisions it likes, but
It's recognition.
direct entirely to recognition in the UK.
Precisely that. This is a harmonisation directive.
Yeah. So
It's
you
a
recognise that in practical terms, Portuguese law, for Portuguese law purposes, would say that was binding, at least subject to being set aside in the Portuguese courts. But you say when it comes to recognition, the
Precisely
English
that.
case could say, we're not interested.
Precisely.
Irrelevant.
That is the central issue in this case. Portuguese law, with respect, can do whatever it likes in Portugal. And it can have effect in Portugal if Portuguese law says it should have effect. The question with which we're concerned is the circumstances in which English law has to recognise decisions of Portuguese law as if they took effect in English law. And that is circumscribed by whether or not those actions, those decisions, come within the reorganisation measure definition, included within which is whether or not they were the exercise of a resolution power or the use of a resolution tool. And again, just so that the court has this, we say that whilst the August decision was plainly the exercise of a resolution power, it was a transfer, and therefore it operated under Article 41. The attempt in December to do whatever it is the Portuguese administrative authority thought it was doing, and we'll look at it in a moment, does not come within any of these powers. And whatever effect it might have in Portuguese law, because it doesn't come within the exercise of a resolution power or the use of a resolution tool, nor indeed is it a measure intended to preserve or restore the credit institution, it doesn't come within the system which has been established in Europe, in accordance with which English law has to recognise and give effect to that in English law. The reason, again, that matters is we're dealing with an English law contract, and whatever effect these measures might have in Portuguese law are really irrelevant so far as an English law contract is concerned, unless they can have effect in English law. Can I just show the court one or two more definitions within the EBRD? If I can take you back to page 1255. Article 220, I've shown the court resolution tool. Resolution power means a power referred to in Article 63 and 272. And again, the reason I'm showing the court these two definitions...
Where have we gone again?
I'm at 1255.
Yep.
Article 2 20 in the definition. The reason I'm taking the court to the definitions of resolution tool and resolution powers is because, as the court saw, as a result of the amendment to the resolution directive, the reorganisation directive by Article 117 of the EBRD, in addition to measures which are intended to preserve or restore, which become reorganisation directives and therefore fall within Regulation 5, you'll recall that the amendment by Article 117 said that included within the reorganisation directive should be the resolution tools, exercise of resolution tools or resolution powers. I've shown the court a resolution tool. Resolution power, as you see, the definition says, means a power referred to in Articles 63 to 72. If I can invite the court to go to page 1335. Article 63, one has as the first article under the chapter dealing with resolution powers, member states shall ensure that the resolution authorities have all the powers necessary to apply the resolution tools to institutions and to entities referred to in points B, C, and D of Article 1.1 that meet the applicable conditions for resolution. In particular, the resolution authority shall have the following resolution powers, which they may exercise individually or in any combination. And one then has set out a series of very specific powers, which go on, as the court sees, for over a page, followed by which one has a series of articles running from Article 64 through to Article 72, again dealing with resolution powers. Now, I'm not going to take the court through any of these. I'm going to take you to Article 66 in a moment. The reason I'm not going to take the court to any of these is because none of my learned friends say that the December decision fell within any of the resolution powers here set out. That was expressly accepted by my learned friend Mr. Salter in front of Mr. Justice Hamlin. What they do say, and this is an argument I'll have to come back to, is that this is a minimum toolbox, a toolkit, and that although it's not specified in the pages and pages of resolution powers, it's okay for the Portuguese law to include within its own legislation further resolution powers and to exercise those powers. I'll come to this in a moment, but whether or not that's the case, the oddity about that submission is my learned friend Mr. Salter doesn't identify any resolution power, which he says was granted by Portuguese law to the BDP, and which therefore enables him to say that the December decision was the exercise of an additional resolution power. It's not really clear where this argument goes. We say in any event that the attempt to say that this is a minimum toolbox and that you can, as a matter of Portuguese law, add further resolution powers which have to be recognized by all of the other member states. Whatever the resolution power you want to add, it has to be recognized by every other member state. With respect, is not justified either by the words which are used in Article 63 or by a scheme which is intended to be a harmonization scheme with mutual recognition, because one can just see the sort of chaos that would result. Whatever Portuguese law says is a resolution power, every other member state has to recognize, just because they say it's a resolution power. As I say, the argument goes nowhere, because Mr. Salter accepts, he certainly hasn't been able to identify, never has, any resolution power, additional resolution power, which he says was given to the BDP, which they exercised in respect to the December decision.
Suppose that the original reorganisation measure in August had said that the liabilities transferred shall be such liabilities as the Bank of Portugal may from time to time determine, and 6 months later they issue a determination. Now, that's essentially a procedural aspect of the original decision. Now, would that fall to be recognised or not?
The original measure would fall to be recognised, and when they determined what fell within, that would be recognised under Article 3.
Yes.
Because that would be implementing the reorganisation.
What is the difference between that situation and what actually happened?
What actually happened is you have a measure which was complete and autonomous from the, I'll show you in a moment. The August decision was complete and autonomous. It took effect without any other decision.
As a matter of Portuguese law?
As a matter of Portuguese law.
Yes.
And that's common ground.
Yes. But why does that matter? Because if you look to Portuguese law to discover the ambit of whatever decision is made, why should you not also look to Portuguese law to determine whether a subsequent decision can modify the effect of an earlier one?
Well, just to be clear, there's no suggestion that the subsequent decision modified the earlier decision. In fact, it's not clear what it was.
All right,
This gives rise to
determined
issue two.
conclusively the effect of it. I mean, I'm thinking of paragraph 47 of the SFI, 47 sub 3, which identifies it as common ground that an administrative authority has power to enact administrative decisions establishing legal rights and obligations for third parties in specific situations. Now, if that is part of the framework of Portuguese law, in relation to which we have to examine the August agreement, I mean, if it is, on the face of it, the December decision might be relevant to the August one.
Well, we don't dispute that it might be relevant.
Yeah.
This gives rise to issue two. On the basis that it isn't itself a reorganisation measure, the next question is, does the December decision, notwithstanding that, by virtue of Article 3, in a sense, tell you what effect the August decision had as a matter of Portuguese law? Of course, as the Court knows, we have three arguments that arise in that context. Number one, whether in fact the December decision is capable of telling the Court what effect the August decision has as a matter of Portuguese law. And that gives rise to the guaranteed trust point that I'm going to have to
Yes.
And secondly, even if the December decision, notwithstanding that it's in a sense, equivalent to a first instance decision in Portugal, which on the basis of the evidence before the English court is likely to be overruled. And that is a key proposition, an indisputable proposition actually. It's a decision which is likely to be overruled on the basis of the evidence before the English court. And I say that because it relates to a factual finding, namely, was the August decision an excluded liability or not? And on that point, the evidence before the English court is that the appellants, that's to say my clients and GSI, have the better of the argument that it was not an excluded liability. That is to say, it is more likely than not that the Oak liability was indeed transferred by the August decision. Now, the whole basis of the December decision was to say, no. I'll show you in a moment what it says. It's effectively a holding the ring decision.
Right.
It says it will take a court to decide this, but we're not satisfied that it was transferred, and therefore, because we're concerned about the possibility of acting in contravention of certain Portuguese legislation, we're going to hold the ring. You're not allowed to treat this as transfer. Now, as to that may be a decision that they take, but on the evidence before the English court, where we have the better of the argument...
You needn't say it again.
Well,
You've got that point.
You've got the point. It is going to be overruled.
Yeah.
And so for the purposes of issue 2, the guaranteed trust point, the question that arises is, are you bound by a decision that you know on the basis of the evidence before you is going to be overruled? I'm sorry, I said it again.
No, we've got the guarantee trust point.
But that's, I was just responding to my Lord Sumption's point about the December decision.
Right. What were the other 2 points on issue 2?
The second point on issue 2 is, even if the December decision is capable of constituting or telling the court what is Portuguese law, and indeed what is the Portuguese law effect of the August decision, did it in fact do so? As I say, for the purposes of Article 3, we're not just looking at Portuguese law generally. It is not enough to say, as a matter of Portuguese law, you take into account the December decision in seeing where we are. The December decision can only make itself relevant for the purposes of recognition by the English court if it is the Portuguese law means by which the August decision was implemented or given effect. And as I shall show the court, there is no evidence before the court that that is indeed the power that the Bank of Portugal was exercising in relation to the December decision. So whilst undoubtedly the December decision has effect, and it has effect in Portuguese law, and whilst undoubtedly that a Portuguese court trying to work out the position in Portuguese law would have to give effect to the August decision and the December decision. It couldn't ignore the December decision. When you come to the English court, you would only give the December decision effect. This is on the basis that it's not a reorganisation measure. You would only give it effect if my learned friends could satisfy you that for the purposes of Article 3, the December decision was the way in which the Portuguese law gave effect to or implemented the August decision. And as I say, there is no evidence before the English court that that is what it does.
Do you accept that it purports to have that effect?
No. Can I just respond to that with respect in this way? The December decision is undoubtedly about the August decision, because it refers back to the August decision. What it does and doesn't do is a matter of Portuguese law. This court can't work out for itself the effect or what the December decision does or was intended to do, or indeed the power which was being exercised by the Banco of Portugal in relation to the December decision, without regard to the expert evidence which there has been before the court on that issue. So, although it refers to it, and in Portuguese law undoubtedly will have to be taken into account in looking at what effect you want to give to the, within a Portuguese court will have to look at it and decide and take it into account in looking at whether, for example, the oak liability had or hadn't been transferred. The evidence before the court does not suggest that this is a power which was exercised by the BDP to implement the August decision. So that's the second of the arguments. The third of the arguments, and this only arises if the court is against me on the first two arguments. In other words, we get to the point where the court says, you're wrong about guaranteed trust. We're happy to give we're happy to regard the December decision as stating.
So if you reject one or two, yes.
You get to the point where we then say that even if that is the position, to the extent that the December decision purports to have retrospective effect in a way that circumvents provisions of the EBRD, this court should not give effect to those retrospective effects.
Just while we're on the issue 2, briefly, it's right, is it, that Article 3, Paragraph 2 of the Reorganisation Directive, which provides the reorganisation measures shall be applied in accordance with the laws, regulations and procedures applicable in the home member state, unless otherwise in this directive, effectively, since the EBRD is a development of the Reorganisation Directive, can one read that as applicable to all aspects of the EBRD?
If it is a reorganisation measure,
yes, provides
the definition of, then yes, it has effect in relation to reorganisation measure, and therefore including in relation to resolution tools and resolution powers.
Yes, because you read the two together.
You do read the two together.
Right, thank you. We better go back to issue 1.
I'm very happy to deal with the issues in whatever order you want.
I think it's unfair to expect you to deal with both of them at the same time.
I will deal with whatever the court wants in whatever order the court wants. Can I just, before I leave this, show the court Article 66, which is at page 1331, and then we can get off, hopefully, the definitions for a little bit. So, page 1338.
1338.
1338. Article 66, power to enforce crisis management measures or crisis prevention measures by other member states. Member states shall ensure that where a transfer of shares, other instrument of ownership or assets, rights or liabilities includes assets that are located in a member state other than the state of the resolution authority, or rights or liabilities under the law of a member state other than the state of the resolution authority, the transfer has effect in or under the law of that other member state. And that, you'll recall, is the provision that was added by the order of 2014, which amended Regulation 5 of the 2004 regulation. And then 3 Member States shall ensure that shareholders, creditors and third parties that are affected by the transfer of shares, other instrument of ownership, assets, rights or liabilities referred to in paragraph 1 are not entitled to prevent, challenge or set aside the transfer under any provision of law of the Member State where the assets are located or of the law governing the shares, other instruments of ownership, rights or liabilities. And I'm showing the court this really just to make the point that this has got no relevance whatsoever to the present case, because we do not seek to challenge a transfer. I refer you to this because my learned friends at some point will refer the court to Article 66, and it's as well that you see it. But as the court would appreciate, this is about inhibiting the way in which transfers can be challenged in other member states. We are not challenging a transfer. Indeed, we are embracing the transfer. The transfer took place in the August decision. So I show that to the court for that purpose. Now,
this is sort of dealing with the Russian bank argument, that all that the Russian revolutionary measures could do would be affect assets in Russia. Is that what it's doing?
Something like that. Some law which says you can't affect any assets which are in our jurisdiction. You don't have to do that. But we're not, as I say, trying to challenge a transfer by reliance on English law at all. Now, can I just make 4 observations, having shown the court at some speed a lot of these definitions? The first observation we would make about these directives is this. As the court will have seen, the EBRD in particular is a detailed scheme which provides for the recognition of specific measures, that is to say reorganisation measures, the exercise of resolution tools and powers and transfers, all of which are defined. We submit that this detailed scheme would be otiose if the English court simply had to recognise whatever a resolution or any other administrative authority did, regardless of whether what they were doing was exercising resolution powers provided for by the directive. And the same would be true if there were an obligation on the English court to recognise a final state of affairs. And I use that phrase deliberately because that is a phrase that one repeatedly sees used in my learned friends' submissions. The same would be true if the obligation was to recognise a final state of affairs in the home member state, again regardless of whether one had arrived at that final state of affairs by means of the exercise of powers that were or were not powers delineated by the EBRD as ones requiring recognition. And again, as I say, it's relevant to make that big point because of the way in which my learned friends occasionally put their case. This may be a European directive, but that is not a reason, we respectfully submit, to lay aside all the usual analytical tools that the English court uses when construing legislation. You must ask whether or not the December decision, this decision by the Portuguese administrative authority, actually comes within the directive, whatever their intention might have been, and whatever the position in Portuguese law. The second general observation we would make is this. We have made it clear, I hope sufficiently, that we do not dispute in any way that where the EBRD is applicable, it must be applied by the English court. It is no part of our case to undermine the principles of universality and unity on which my learned friend Mr. Salter, in particular, places such emphasis. As for unity, we accept that it is only for the competent authorities of the home member state to decide what, if any, reorganisation or resolution measures to impose. As for universality, we accept that if a measure is a reorganisation measure or the exercise of a resolution tool or power, then it falls to be recognised as pursuant to the 2004 regulations and must be given the effect that it has under the law of the home member state. But we say equally that if a measure is not in one of these categories, then subject to issue 2, it is simply irrelevant to English law. Third of my observations, and this is closely related to the point I've already made, the court will have seen on a number of occasions Novo Banco and the BDP referring to the resolution or reorganisation as a process. And again, we respectfully submit that is true, but of no assistance whatsoever. It is true that the reorganisation resolution of a bank in trouble will be a process. It will take time, and it may involve multiple decisions by the resolution authority. But with respect, that does not mean that one simply recognises everything the resolution authority does. One still has to ask whether each of these various decisions, properly construed, falls within the directives. If they all fall within the directives, they will all be recognised. If not, then again, subject to issue 2, they are irrelevant, whether or not part of the process. And fourth, again, to be clear, the present case is not a case where we, the appellants, are setting up some sort of clash between English private law and foreign administrative law, or between English private law and European bank resolution law. Again, as we've made clear, we accept that if foreign administrative measures fall within the mutual recognition provisions, then they must be recognised. But the very question in this case is whether they do. And if they do not, then again, subject to issue 2, they are irrelevant. And there is, contrary to Novo Banco's case, nothing parochial or anomalous in the position that we take. I suggest that the court should take.
Well, there will potentially be a clash, won't there? I mean, assuming that the challenge in Portugal were not resolved for a long time, or assuming it were resolved against your clients, your case would be that you could go ahead with English proceedings and get judgment in them, irrespective of the Portuguese view or any Portuguese decision, I think.
I'm not suggesting that there may not be a different outcome depending on whether you apply Portuguese law
Approach, yes.
or whether you apply English law.
Yeah.
We just say this is an English contract, you apply English law, and to the extent that Portuguese administrative decisions count as English law, you apply those. We're not setting ourselves up as against the application of the European directive if it applies.
Right.
What we say, as I say, is don't apply it if it doesn't apply.
Portuguese law is otherwise irrelevant.
Exactly that.
Yeah.
Can I then, again, very briefly, so I've shown the court, I hope, sufficient of the regulations and the directives so the court has a feel for what the issues are. Can I next just take the court to the 3 relevant decisions of the BDP that lie at the centre of this dispute? Again, for the court's note, these are all set out in the Court of Appeal judgment, Core Volume 2, Tab 14, pages 402 to 403. And again, the court, given that, I'm going to take these reasonably quickly. Can I begin with the August decision? That's at Core 2, Tab 17, beginning at page 448. And the decision itself begins at page 453. This is the decision made, as you can see on the first page, 3rd of August 2014 by the Bank of Portugal. The bank, I'm picking this up on page 453, the Board of Directors has decided as follows. Point 1, setting up of Novo Banco SA. Novo Banco is set up under the relevant provision of the Portuguese law. That's the setting up of the bridge bank. And then point 2, transfer to Novo Banco SA of assets, liabilities, off-balance sheet items and assets under management by Banco Espírito Santo SA, pursuant to, again, the Portuguese law, in conjunction with Article 17A of another Portuguese law, assets, liabilities, off-balance sheet items and assets under management by BES are transferred to Novo Banco as listed in Annexes 2 and 2A of the deliberation. So that then takes one to Annex 2. You'll find that at page 463. That's the decision that there should be a transfer. You go to Annex 2 to look at what should be transferred, or what is transferred, in fact. as I say, 463. Assets, liabilities, off-balance sheet items, and assets under management of BES recorded in the accounts that will be transferred to Novo Banco according to the following criteria. And then A deals with assets, licenses, and rights, including property rights of BES, will be transferred in full, and then certain exceptions. We're concerned with B. BES's responsibility to third party that are liabilities or off-balance sheet items will be transferred in full to Novo Banco, with the exception of the following excluded liabilities. And that is where the definitions of excluded liabilities arises. And then B1, is where you have, for present purposes, two relevant criteria by reference to which liabilities might be excluded. Under A, there is a reference to the exclusion of liabilities owed to shareholders whose participation is equal to or higher than 2% of the share capital. And it is said that Goldman Sachs fall within that category. If you then drop down to C, right at the bottom of the page, spouses, first-degree natural or in-law relatives, or third parties acting on behalf of the persons or entities referred to in the foregoing paragraphs. And it is said that my clients, the Oak parties, are third parties who are acting on behalf of Goldman Sachs. So that's the basis upon which it is said that the Oak liability was an excluded liability for the purposes of this definition. If I can then just invite the court to go over the page 65. Just to pick it up two-thirds of the way down, after the description of the various categories of excluded liabilities, just picking it up, as you see, the words, after the transfer referred to in the foregoing subparagraphs, Banco de Portugal may at any time transfer or retransmit assets, liabilities, off-balance sheet items and assets under management between BES and Novo Banco in accordance again with Portuguese law. So Portuguese law gave Banco de Portugal the power to do retransfers in accordance, indeed it had to give it those powers, in accordance with the EBRD. And it had that power which it could have exercised. Now,
Well, you say Portuguese law, but in terms of European law, you say this is, although part of the same scheme, nonetheless not a reorganisation measure.
no, we say this is the August decision.
Ah, sorry, this one, yes.
This is the August
Yes, I
decision.
see.
And this was a
Yes.
transfer. This is full square into Article 41 and I think 5.
So if it had retransmitted assets, you accept that the later decision to retransmit would be
Exactly. If the
part of this reorganisation decision.
if the December decision is a retransfer, we accept it's a reorganisation measure.
I see.
But as you'll see, it's not. Basically, they messed up. Well, they think they messed up, but we'll come to it. So
Well, on
just
on your case, what, they messed up because they failed to accept that they had originally transferred and were seeking to retransfer.
Well, in our case, what happens is about 2 weeks before they're due to pay a very substantial dividend
Yes.
under this, someone thinks, what if we're wrong? And what if Goldman Sachs did hold 2%?
Yeah.
And what if my clients were, for some curious reason, acting on behalf of Goldman Sachs? What we had better do is make sure we treat this as if there never had been a transfer. And that's what you'll see happens in the December decision. I'm not getting into the motivation. As a matter of chronology, it's undoubtedly the case that this was done just before a very substantial dividend would have been paid. But it may be, on the face of it, what they say in the December decision is there's a concern that they're acting in contravention of Portuguese law by possibly transferring, because that's as far as they take it, possibly transferring liabilities which shouldn't have been transferred because they fell within the excluded liabilities definition, which are enshrined in Portuguese law. You cannot transfer a liability owed to a person who holds more than 2% of the shares. So that's actually what was happening in December. There's a concern that, this may be a problem, let's stuff it back in the bad bank, and a court will determine in due course what the position is. It's basically an interim injunction.
Well, if they'd done it differently, if they'd simply said, look, we don't believe we have, there has been a transfer of this, and we shall stand on that position, but in case we're wrong, or against the event we're wrong, we also will retransmit. Couldn't they have done that?
Well, perhaps, but there are issues in Portuguese law as to whether you're able to do that.
That's what they purported to do in
September. Exactly, and there are arguments between the experts as to whether you're allowed as a matter of Portuguese law to do that. We don't have to get into this.
Well, because it's inconsistent positions.
Inconsistent positions, and whether as a matter of Portuguese law that can have Portuguese law effect at all. But that's, as I say, not before the court.
Yeah.
For a variety of reasons.
All right.
But there might have been a way of doing it. I don't know, but as I say, so far as this court is concerned with, it's just the December decision, which you'll see is not a retransfer. Now, I've shown you the August decision. Can I just make two very quick observations about the August decision? The first is that the August decision is directed at every single asset or liability of BES. Oak was either, therefore, transferred or not transferred. There is no third possibility. And it is common ground between the experts that the August decision was complete and autonomous so far as concerns the category of liabilities with which we are concerned. And I make that point, and it's an important point when we get into issue 2. You didn't need an implementing decision. You didn't need any other decision.
What do you mean by autonomous?
It had effect on its own without a further decision being required in order to give it effect.
And does that mean that if Portuguese law provides for the possibility of a further decision, it's somehow to be ignored?
No. All I'm saying is you certainly don't need the December decision to give effect to the August decision. And that is what raises the question, well, if you don't, what is the relationship between the December decision and the August decision as a matter of Portuguese law? As I say, it was complete and autonomous so far as concerns the category of liabilities with which we are concerned. And I think this is actually accepted in Novo Banco's case. I'm not inviting you to turn it up, but at paragraph 53, core 1, tab 10, page 321, it is accepted that this was complete and autonomous. And in any event, that is the position that the experts take on this point. No implementing act of any kind was required in relation to the Oak liability. The second observation, and it's related to the first one, reflects a point I made in opening, whether Oak was transferred depends on the essentially factual question, and I'm going to say it once more, as already noted, we have the better of the argument in relation to that question. So Mr. Hamlin found, and there was no appeal. Mr. Justice Hamlin found, and there was no appeal against that decision. For the court's note, that is at paragraph 85, core volume 2, tab 16, page 440 of Mr. Justice Hamlin's decision. So that's the August decision. Can I next invite the court to go to the December decision, which is at tab 18 of the same bundle, beginning at page 470. I'm going to invite the court to go to 482. There are two translations. I was using the one beginning at page 482. One then has, just halfway down 482, a resolution, and you have a preamble which sets out the background to the December decision. And just picking this up at paragraph 4, according to the conclusion of internal Bank of Portugal analysis, the court's note that's at 474, there are serious and well-grounded reasons to justify the conviction that the Oak Finance acted in the granting of, I think it was a Goldman Sachs debt, and just 5, therefore the transfer of the liability of BES to Oak cannot be allowed, seeing the serious risk of allowing an irreparable violation of the provisions of point 1b2 of Annex 2 of the resolution of the Board of Directors of the Bank of Portugal of the 3rd of August. And then we have this, pursuant to the provisions of Article 145 and Article 145G1 and H2C, and based on the grounds contained in their internal memo, the Board of Directors of the Bank of Portugal resolves the following. A, the liability of BES to Oak Finance resulting from the financing contract on 30th of June was not transferred to Novo Banco. This ruling is effective as from 3rd of August. And then C, Novo Banco and BES are to adjust their accounting records to this resolution and act in accordance with what is ordered herein. So that's the December decision. And then can I, finally, in terms of the decisions, invite you to go to the February decision, which we have behind tab 19, beginning at page 498. Just so the court understands this, the February decision arises because, as you see from point 1, Goldman Sachs complain about the December decision, and so the Bank of Portugal looks at it again. And if I can just invite you to look at certain paragraphs of this, if you're at page 498, paragraph C, the documentation submitted by GSI with its memo of the 31st of December 2014 does not constitute certainty that the financial instruments disclosed in the market did not confer a position of influence over the exercise of voting rights in BES. G, it is not possible to deem that the claim that the debt instruments issued by Oak Finance to obtain the funding required were placed by GSI in the hands of third-party investors on the issuance date. So this is all about the facts. Then I, any margin of doubt or uncertainty on the fulfillment of the premises for the prohibition of the transfer of BES liability resulting from the loan agreement with Oak can only be overcome with a very high degree of certainty. J, said degree of certainty can only be reached by an entity with power to issue a final decision, i.e. by a court of law. K, the requirement of a court ruling also results from the imperative of avoiding the creation of difficult, reparable situation which cause an irreparable breach of statute. L, GSI's exposure is not sufficient to weigh the serious and grounded reasons on which the decision of the 22nd of December was based. And then you see at the bottom, the Board of Directors decide to confirm and maintain its decision of the 22nd of December. So it is in effect an interim injunction or a freezing of the position. It's a decision that their decision should not be given effect in relation to the August decision. And we respectfully submit that what the December decision was doing is accurately described by Mr. Justice Hamlin at paragraph 101 of his judgment. And since we have this volume open, can I invite the court just to look at that? Paragraph 101, it's at page 444, behind tab 16. In effect, top of the page, paragraph 444, page 444, sorry, paragraph 101. In effect, the Bank of Portugal is seeking to bring about a result which is not provided for under the EBRD, namely to prevent a transfer from taking effect unless and until a court of law has determined that it is effective. If, however, the facts are that the Oak liability is not an excluded liability, then that liability was transferred. There's no explicit or implicit requirement that it must first be determined by a court of law. So that, we say, accurately describes what they were doing. Just before leaving the February decision, can I just...
When you say it's not provided for under the EBRD, would it have been possible under the EBRD for the reorganisation, the August decision to have said any transfer shall be liable to be set aside if a court determines that there wasn't a 2% interest or something like that?
I'm sure it doesn't even need to say that. Because I'm sure the reality is, just going back to the August decision...
It will only take effect if a court determines that there is less than the 2% interest.
Well, if the August decision, just going back to it, the reason I said it was complete and autonomous, it either was transferred or it wasn't transferred. Yeah. So all that would happen is the court says it was transferred or the court says it wasn't.
Yeah.
So one doesn't need that. Unless your Lordship wants to ask me something else about it, can I just show your Lordships and your Ladyship, before we move off the February decision, a paragraph in a memo which accompanied the February decision. This is at page 500, begins at page 501, the memo. The relevant passage is paragraph 30 towards the end, specifically on page 540. Can I just draw this to the court's attention? It's just one paragraph here, page 540, the paragraph beginning, "in such circumstances."
Yeah.
In such circumstances, having complied with the required duties of structural care and its duties of care and good faith in the evaluation of the reasons submitted by the interested parties, the Bank of Portugal, albeit with margin for doubt, must apply the restrictive provisions contained in paragraphs A and C of Article 145H of the Portuguese banking law. If serious and grounded reasons exist to support its undertaking that the assumption of restrictive provisions are met, the Bank of Portugal must apply said provision, otherwise potentially giving rise to an irreversible situation with the transfer of liabilities to the bridge bank. The risk of irreparable breach of statute is entirely linked to the transfer of liabilities. If they are deemed not transferred, as in the case of the decision of 22nd December, and that decision is voided by a court of law, there would be no significant complication in restoring the situation of the interested parties and compensating any eventual damages caused by the decision of the authority which decided the resolution. Now, what is curious, of course, is that all that is happening in the English litigation is an attempt to decide that factual question. That is the issue on which the jurisdiction point depends, and if we win on that point, if we establish before the English court that the oak liability was not an excluded liability, we will have established that factual issue. There's no reason at all why that factual point cannot be dealt with by the English court. So the whole structure which the Portuguese Bank of Portugal is building with a view to not having this liability transferred until the court of law has had the opportunity to consider it is not inconsistent with what we're trying to do. All we want to happen is for the court in England, which is the proper law of the facility agreement, to consider that factual point. Now, that was all I was going to show the court in terms of the three decisions that are relevant for the purposes of the matters before the court now. Can I then move on to deal with what I described as issue one? And that issue concerns whether the December decision is a reorganisation measure in its own right. And again, just to remind the court, it's common ground that it is a reorganisation measure in its own right only if the December decision comes within one of the three gateways identified in our written case at paragraph 36. Either the pre-amendment gateway, on the basis that it was a measure intended to preserve or restore the credit institution, or that it was a transfer under the EBRD, or that it was otherwise a resolution tool or power, again, under the EBRD. Perhaps I can just say something about each of those in turn. First, can I deal with the pre-amendment gateway? And can I invite the court for this purpose to go back to Article 2 of the Reorganisation Directive, that's Authorities Bundle 1, Tab 1, page 1225.
Page 12.
1225. Or if you prefer, you can also look at it in Article 117 of the EBRD, which amended this, but for present purposes, it's sufficient to go to Article 2. Reorganisation measure, this is at the bottom of 1225, shall mean measures which are intended to preserve or restore the financial situation of a credit institution. That's the only bit that we have to be concerned about. And the key question, so far as concerns the present court, is whether it can be said that the December decision was a decision intended to preserve or restore BES's financial situation, BES being the credit institution under resolution. Was the December decision a decision intended to preserve or restore BES's financial situation? Now, so far as concerns the construction of the definition, as the court knows, we say it means what it says. We say when it says that the decision must be one intended to preserve or restore the financial situation of a credit institution, that is what it must be to come within the pre-amendment part of this definition. It cannot be a reorganisation measure unless it is intended to preserve or restore the financial situation of the bad bank. And that, for the court's note, is consistent with what is said by the Court of Justice in Kotnik. Perhaps I can just very quickly show this to you. Kotnik is the Court of Justice decision, Authorities Bundle, Volume 1, Tab 8. It begins at page 1501. If I can just invite the court to go to page 1558, paragraphs 106 to 108. So page
Page.
1558.
Thank you.
Now, I'm going to show the court paragraphs 106 to 108, but can I just make this point? The court will note that this is a 2017 decision. That is to say, it's a decision about the meaning of these words after the Article 117 amendment of 2014. And I make that point because my learned friend Mr. Salter seeks to make an argument to the effect that as a result of the Article 117 amendment, we should give these words in the pre-amendment definition a meaning which is different from the language of the definition, notwithstanding that there's no change to the words at all. And it's perfectly clear from Kotnik, which, as I say, is a post-amendment case, that what he says is simply not right. If you look at paragraph 106, one sees the court first refer to Article 2, 107, I don't think the court needs to be concerned about, but effectively what one then gets in 108 is the court trying to define various aspects of this definition. First, given that and it's talking about burden-sharing measure was the issue before the court, given that the burden-sharing measure is to restore the financial position of credit institutions and to overcome their capital shortfall, as set out in point 43 of the banking communication, the purpose of those measures is to preserve or re-establish the financial situation of a credit institution. And that, as you see, is what the definition says. Now, as I say, the reason it matters is because Mr. Salt has an argument which he says you don't need to worry about whether it's intending to preserve or restore the financial situation of a credit institution. You could have, he says, a reorganization measure within that language, the preserve and restore language, even if the purpose of the measure is that the company should be wound up, as long, he says, as the purpose is to protect the financial activities of the company, which he says the December decision, I think he must say this, is. With respect, that simply bears no relationship whatsoever to the meaning, to what the words of the definition say. And just one gets a similar, I've shown the court paragraph 108. If I can invite the court, since we're in Kotnik, to go back to page 1538 in the opinion of the Advocate General Wall, page 1538. One sees just paragraph 135, again, the Advocate General is setting out the various elements of the definition. And again, at the top of page 1539, you see he says the measure must be adopted with the purpose of preserving or restoring the financial situation of a credit institution. Again, completely inconsistent with the argument that Mr. Salter wants to advance as to what the meaning of this expression is. Now, we say that it is plain that the December decision cannot possibly be regarded as a decision which was intended to preserve or restore the financial situation of BES. In the first place, as the court has seen, it is a decision which is simply not concerned with the financial situation of BES at all. What is intended to do is to try and avoid what the Bank of Portugal was concerned might be a breach of its own banking legislation. It was intended to hold the ring, not to preserve or restore the financial situation of BES. Moreover, to the extent that the December decision had any effect at all on BES, it was a decision which was intended to make BES's situation worse, not better, by in some way deeming, I want to be careful about the language that they use, in some way saying that an $800 million liability which everyone thought, the Bank of Portugal thought, Novo Banco thought, everyone thought this had been transferred to Novo Banco. The Bank of Portugal wanted to say that that should remain with BES. How is it that a measure intended to make the position of BES worse can possibly be a measure intended to preserve or restore the position of BES? With respect, it is simply impossible to see how that argument can run. I should just say this, that not only is it extremely difficult to understand how the argument can be made, Novo Banco produced no evidence before Mr. Justice Hamlin that suggested that the purpose of the December decision was to preserve or restore BES's financial situation. Now, the court will have seen that there are two broad arguments which my learned friends Mr. Salter and Mr. Howard advance in response to our position. The first argument, as I say, is Mr. Salter's argument alone. He says, never mind what the words actually say, because of the amendment to the definition brought about by Article 117 of the EBRD, which deemed certain other things to be included as reorganisation measures, he says that if a measure is seeking to preserve or restore the financial activities of the bad bank, that is enough, even if the measure is not intended to preserve or restore the financial situation of the credit institution itself. That's paragraph, for your note, paragraphs 115 and 118 of his case, core 1, tab 11, page 346. So as long as it's intended to restore the financial activities of the bad bank, that's enough, even if not intended to preserve or restore the financial situation of the credit institution. Now, as I say, we respectfully submit that that is plainly wrong. The amendment cannot affect the meaning of words which were already there, where those words were not amended in any way at all. Nothing in the language of the amendment or elsewhere suggests that one can just ignore the clear language that is used in relation to the definition at Article 2 of the Reorganisation Directive, which make clear, as I've shown you, that it is the financial situation of the credit institution itself that is to be preserved or restored. And we also say that what Mr. Salter is submitting is inconsistent with Kotnik, and I've taken your Lordship and your Ladyship to the paragraphs in Kotnik where, notwithstanding that it is a post-amendment case, the definition is given exactly the same meaning. And just for the Court's note, in Kotnik, at paragraph 140 of the Advocate General's speech, he actually specifically refers to the amendment making no difference to the scope of the definition. Now, the second argument that is advanced by my learned friends, both by Mr. Howard and by Mr. Salter on this occasion, it is said that Article 2 applies to measures intended to stabilise the bad bank, even if what is intended is that the bad bank will ultimately be liquidated or wound up, so that a measure that facilitates the orderly winding up of a credit institution is to be regarded as one that preserves or restores that institution's financial situation. And again, for the Court's note, this is what Novo Banco say at paragraph 116, core volume 1, tab 11, page 347. It's what my learned friend Mr. Howard says at paragraph 55 to 57, core volume 1, tab 12, page 379. And there are a number of points to be made about that. And perhaps first and most obviously is this. There is, with respect, an overriding and overarching threshold difficulty with this argument. Even assuming, contrary to our case, that Article 2 extends to such stabilisation measures, measures intended to facilitate orderly winding up, even assuming that Article 2 extends to such measures, while that might conceivably, I don't say it does, but while it might conceivably cover the August decision, which on the face of it, which was a decision that was made to prevent a problem arising in the Portuguese financial system generally, it cannot on any view cover the December decision, which is the decision with which we're concerned. As already noted, the December decision was a measure that sought to increase, not decrease, BES's liability by some $800 million. That obviously cannot have been intended to stabilise BES even temporarily. And that is actually a point which is evident in the way the argument is formulated in the BDP's case at paragraph 57, page 380 of Core Volume 1. And I say that because even Mr. Howard, when he wants to run his orderly, when he wants to run his orderly winding up point, stabilization point, can only do so by treating the August decision and the December decision together. He cannot make the point simply by reference to the December decision alone. He can only do so by saying, well, look at the August decision and the December decision together, and collectively they might be seen as some kind of stabilization. With respect, they can't. But that's not the point. It's completely beside the point. The question is, can the December decision be treated as a stabilization measure? And we respectfully submit it's plain that it cannot. So we say the legal argument as to whether measures which are simply intended to stabilize prior to winding up can count as measures which are intended to preserve or restore is actually academic in this particular case, on the facts of the case. But we say, in any event, that so far as there is this argument, my learned friends are wrong. The preserve or restore does not extend to orderly winding up where the purpose is to actually wind up. And all you're doing is stabilizing as a route. In other words, a nice sending off, if I can put it that way, as opposed to preserving or restoring. So we have the following points. First, there is nothing in the language of the definition that supports that interpretation. Secondly, that definition, my learned friend's approach to the definition, is inconsistent with Recital 6, Recital 14, and Article 12.1 of the Reorganisation Directive. And perhaps I can just show the Court why. Can I invite the Court to go back, please, to the Reorganisation Directive? It's an article, Authorities Bundle 1, Tab 1, page 1223 for Recital 6. It's, if you have that, it's on the right-hand column. The words I want to draw to the Court's attention are the last few words. The Court sees necessary to establish mutual recognition by the Member State of the measures taken by each of them to restore to viability the credit institutions which it is authorised. So that is what this is about, restoring to either preserving or restoring to viability. Then if I can show you Recital 14 over the page. Left-hand column, about halfway down. In the absence of reorganisation measures, or in the event of such measures failing, the credit institutions in difficulty must be wound up. Now, what that does is to juxtapose success of the reorganisation measures with winding up. If the reorganisation measures succeed, there will not be a winding up. That's effectively what that's saying. My learned friend's definition of what can possibly count as a reorganisation measure doesn't fit in with that, because one can quite see a stabilisation measure succeeding, but you would still have a winding up. In other words, a successful reorganisation measure and a winding up. That is consistent with what Recital 14 envisages, which is that if the reorganisation measure succeeds, you will not have a winding up. And it is only if it fails that you'll have a winding up. Then Article 12.1 on page 1228, since it's a similar point, top of the page, where the opening of a winding up proceedings is decided on in respect of a credit institution in the absence of following the failure of reorganisation measures. So again, you have the juxtaposition between a reorganisation measure failing and a winding up. Mr. Howard's case, you could have a reorganisation measure succeeding and a winding up, because he says it can be simply about the orderly procedure towards winding up, stabilising prior to winding up. And that is inconsistent, as I say, with those provisions. Now, in addition to those points, as to why we say we're right about what is ultimately just maybe a sterile academic point, because on the facts, given what the December decision is about, it simply cannot be intended to preserve or restore. There's also first instance authority, both in this jurisdiction and indeed in Germany, which is inconsistent with Mr. Howard's and Mr. Salter's approach to this provision. I'm not going to invite the Court to turn these up. They are referred to in our written case at paragraph 41, subparagraph 2, Core 1, tab 9, page 185. They are Mr. Justice Burton's decision in Rawlinson at paragraphs 20 to 22, Authorities Bundle, Volume 4, tab 32, page 2460 to 2461. Also inconsistent with the decision of the Munich Court, Munich 1 District Court, Authorities Bundle, Volume 5, tab 42. And there is a note by Professor Timo Fest relating to the Munich decision, again making the point that we make, which is that the reference to intended to preserve or restore must be to preserve or restore to vitality or viability. That's all I was going to say about the first of the gateways, which is the pre-amendment gateway, the preserve or restore point. That just leaves two other gateways.
Could you just help before you move on from that as to why the August decision did fall within the definition of reorganisation measure when it was transferring the large debt to the bank which was meant to be making this all work?
It didn't fall within that part of the definition. It was not. Contrary to what the Court of Appeal might have thought, and I'll take you to, I think it's paragraph 34, we never said that the August decision was within preserve or restore. What we said was that it was a transfer, and therefore either the exercise of a resolution power or an Article 66 point, and on either head would come within the definition of a reorganisation measure.
So this isn't covering this sort of thing at all, the August measure at all?
It isn't. This was a late argument which Mr. Salter, I think, came up with in the Court of Appeal when other avenues didn't, or Mr. Howard, when other avenues didn't look good, and they had to amend their grounds. But in our respectful submission, it goes nowhere. Can I then move on to as I say, there are two gateways left. There's the transfer gateway, and then there's the resolution powers and tools gateway. I'm going to deal with the transfer gateway first, because with respect, if it's not within the transfer, I'm going to face this way a little bit more as well. If it's not within a transfer, it's very difficult to see what other resolution power or tool it could possibly be. So gateway number 2, transfer. And as I say, this is the way in which the August decision comes within the reorganisation measures. For the court's note, we deal with this at paragraph 53 and onwards of our written case. That's Core Volume 1, tab 9, page 196. Now, both courts below held that the December decision was not a transfer. For the court's note, again, this is Mr. Justice Hamlin between paragraphs 94 to 101, Core Volume 2, tab 16, page 442 to 444. The Court of Appeal, in Lord Justice Moore-Bick's judgment at paragraph 9, that's Core 2, tab 14, page 407, and in Lady Justice Gloucester's judgment at paragraph 41.3, Core 2, tab 14, page 411. And we say, with respect, that the Court of Appeal was right about this, or at least the majority was right about this, and that the December decision is plainly not a transfer or even a retransfer. And there are 3 reasons that we identify as to why we say this is the position. First, the terms of the decision itself make clear that it was not a transfer. Second, BDP and indeed Novo Banco themselves have made clear, at least in Portugal, but not to this court, that they do not think it was a transfer or do not say it was a transfer. And third, it is in any event clear from the expert evidence that was before the court, before Mr. Justice Hamlin, that it is not a transfer. Perhaps I can just...
It says the liability was not transferred.
Yeah.
Now, you submit, 1, that it was not a transfer back, and 2, that it didn't purport to determine the effect of the August decision as a matter of Portuguese law. What third possibility is there? If something says it was not transferred, and that is not determining the effect of the August decision, nor is it transferring back, then what is it doing?
As a matter of Portuguese law, it is plainly to be taken into account. As a matter of a Portuguese court would have to take it into account and give effect to the December decision. But that is different from saying that what it is doing is giving effect to or implementing the August decision.
Well, logically, if something says it wasn't transferred, it must either be determining what happened in August, or it must effectively be saying that shall be deemed not to happen, which is legally the same as a retransfer. I'm just curious about how something can be neither one nor the other of those things.
We say it wasn't a transfer, and I'll
Yes.
want to develop that now. In terms of what the Portuguese bank was doing, we say it did not have the power to determine, it was not exercising a power to give effect to the August decision.
Well, yes, I mean,
Can I just explain?
never mind what the power was. What did it purport to do if it neither determined what had already happened, nor effectively brought about a situation as if it had already happened?
It was certainly trying to bring about a situation as if there had not been a transfer. I accept that.
Yes. But I mean, if it wasn't determining the previous effect, then it was in substance retransferring it back.
Well, it wasn't retransferring it back, because effectively what it was doing is it was deeming there never to have been a transfer.
Well, if there had been, how do you achieve that without transferring it back?
Well, that's, as a matter of Portuguese law, one of the issues that arise in this case, because it was trying to exercise a power which it didn't have.
Well, that sounds like an ultra vires argument and not a construction.
Well, it's not before this court, and one of the reasons I don't want to get involved is that
Well, it is before this court,
Well-
because first of all, there's an issue as to whether it was a retransfer, and secondly, you say it didn't purport to determine the effect of the August decision. And I'm
what I
not sure
say,
how you run both of those things simultaneously.
what I say is it wasn't a retransfer, and whatever they were doing in purporting to deal with the oak liability, what they were not doing was, as a matter of Portuguese law, there is no evidence about this. There is no evidence to suggest that as a matter of Portuguese law, what they were doing was seeking to give effect to the August decision. Can I develop this when I get to...
Can I just understand one thing? I mean, it is common ground, isn't it, that the December decision, whatever it means, is effective under Portuguese law. And if there's no evidence about what it means under Portuguese law, then we have to make up our own minds.
Can I ask your Lordship just to repeat that? I'm sorry.
I was going to say, I understood that it's common ground that the December decision is effective under Portuguese law. Now, if there's no evidence about what it means under Portuguese law, don't we just have to make up our own minds?
No, it is common ground that it is effective,
Under
at least
Portuguese
temporarily,
law?
under
Yes.
Portuguese
Well,
law.
whatever it means, it's effective.
Whatever it means, it is effective.
And since there appears to be no evidence as to what it means under Portuguese law, have I understood that correctly? Don't we have to make up our own minds?
By reading it.
What we say is there is evidence before the court as to the nature of the power that might have been exercised in relation to the December decision. This is the second part of issue 2. So where we ask about whether this was, in fact, an attempt to apply or implement the August decision.
I see.
We'll get to this, but what one finds is that there is no agreement between the experts as to the nature of the power that the court was exercising. Effectively, we've got into a position where Mr. Salter, for no doubt forensic reasons, said to the court, both at first instance and indeed especially to the Court of Appeal, he was content to proceed on the basis of some established propositions which one finds set out at paragraph 55 of Mr. Justice Hamlin's decision, 53. And he was content for the court not to determine the remaining issues which were in dispute. And that was a decision that he made. Now, one of the things that was not determined and was in dispute was the nature of the power that the BDP was exercising in respect of the December decision. And that's what gives rise to the decision, the issue in relation to, the second issue in relation to Article 3. In circumstances where Mr. Salter has chosen to go before the court simply on the basis of the statement of Portuguese law that you find at paragraph 53 of Mr. Justice Hamlin, and it is in effect accepted that if there's any other thing that he has to rely on in Portuguese law, well, that's his lookout, because he took the view that he didn't want the court to deal with those matters. If we have an unresolved question as to the nature of the power that was being exercised, and there is no evidence, no fact before the court which says that the power that was being exercised was a power to implement or give effect to the August decision, that, with respect, is Mr. Salter's problem.
Well,
And that may be...
well, I wonder. It may create us a bit of a problem for us, because I mean, it's a rather curious concept to have an agreement that something is effective, but it is said that the experts aren't agreed as to what its effect is. That hasn't been determined, and you, the court, are left in a position where you can't determine what its effect is.
You simply are left in a position where you cannot say that this is...
I thought if there's no evidence about it, the normal position is that we have to make up our mind.
Well, ordinarily, my lord, that is the position if the parties are proceed on the basis of an assumption that English law is the same as Portuguese law. But what we have here is a rather different situation, where the parties each put in expert reports and then supplemental expert reports dealing with all sorts of issues, including this question. But it was Mr. Salter's election that the court should not seek to resolve the issues which were in dispute in relation to the nature of Portuguese law and how it applied, the nature of the power that the Portuguese bank was exercising in relation to the December decision.
If I can respectfully say so, I think there may be confusion between the dispute between the experts as to the basis upon which BDP was acting, i.e. what is the source of the power, and that's a matter that can be ventilated in the administrative court in Portugal. But what is common ground and is recorded in the statements of facts at issue at 47.4 is that the Administrative Act, which defines a party's rights and obligations, is directly effective, and the party's rights or obligations under Portuguese law are as stated, so that you can see in respect of what the December decision says. There's no question of some special rule of construction or anything of that sort. You can see what the December decision says, and the party's rights and obligations are as stated, unless or until that decision is annulled.
Can I think Mr. Howard probably knows full well that that is his case. We have a response to that case. Mr. Howard hangs quite a lot on the fact that the December decision is binding as a matter of Portuguese law. With respect, it's irrelevant. This is not about the status of that decision. It's about the nature of that decision and whether that decision was an implementing decision under Article 3. And whilst it is common ground, and always has been, that the December decision is binding as a matter of Portuguese law, once it comes to the nature of that decision, it has always been an issue. And as I say, Mr. Salter was perfectly happy to proceed on the basis that any outstanding matters he could not rely on, and he cannot say, in the absence of clear evidence, that notwithstanding the absence of this evidence, this is, either by way of assertion, which is what Mr. Howard tends to do, or Mr. Salter, by reference to evidence again, which is not there, this is an implementing act, because there isn't any such evidence. As I say, I'll come to that when I get to the December, when I get to issue 2.
Can we just go back, though, to what power they were exercising when they did this? Paragraph 3 of the agreed propositions, or the propositions in paragraph 53 of Mr. Justice Hamlin's judgment, was about establishing legal rights and obligations for third parties in specific situations. Why isn't it an exercise of that power?
Can my lady just remind me?
431 is the page of the...
And the particular subparagraph...
3.
It undoubtedly has that power. The question is whether it was exercising that power.
Why isn't it exercising that power?
Well, it's disputed as to whether it's exercising that power. So when we come to it, I shall show, my lady, that Professor Moreira, who is the Novo Banco expert, started off saying this is an implementing power. What they were doing was exercising an implementing power, a power to modify. Professor Duarte and Professor Almeida disputed that. They were the experts for Goldman Sachs and my clients. Professor Moreira then backed down He said it wasn't an implementing. He accepted it wasn't an implementing measure. I think he might even accept it wasn't a modification. But what gets left is what power it was that was being exercised. So it's one thing to say there are these powers. It's quite another thing to say that this is the power that was being exercised by the Bank of Portugal in relation to the December decision. And that is a matter of controversy. Can I, subject to the court, just try and carry on with issue 1 and gateway 2? I will come back to this. Transfer gateway. I think I've made the point that the courts below all said this wasn't a transfer or retransfer. And I've made the point that if you look at the decision, if you look at what BDP itself says, and if you look at the expert evidence, again, all three suggest that this was not a retransfer. Can I go back to the decision itself? The December decision, Core Volume 2, Tab 18, page 482. Especially at page 483. And it's really A, the liability of Banco BES to Oak was not transferred. Now that is a statement of fact as they see it. It is not a decision that it should be retransferred. It is a statement of fact as they see it.
No, but just taking Lady Black's reference, on the face of it, it looks like an administrative decision establishing legal rights and obligations. This is how you are to proceed on the basis it wasn't transferred.
Can I try and keep separate issue 2 and article 3
yes.
and whether this is in fact a transfer? I promise you I will come on to that issue.
Yeah.
And the trouble is they are intimately connected.
Well, they are.
It's got to be one thing or the other.
Well, subject to whether the power they were... I understand that what they sought to do, what it appears that they thought they might have been doing, was trying to establish the position as it should be following the August decision.
But what they thought they were doing, if it's agreed that it was effective, is what they were doing.
Effective is a matter of Portuguese law, but the question is whether what you're then giving effect to is the December decision or a December decision which purports to implement or give effect to the August decision. Because if it's the former, it really doesn't help them. As a matter of Portuguese law, it undoubtedly will help them. Can I just take an example? And I apologize. I'm going to move on to issue 2 for a moment, and I'm going to move back to issue 1. Take this situation. In Portugal, there are 2 decisions, Decision A and Decision B. Decision A is a reorganization measure. Decision B is the view that an administrative body has and provides about that reorganization measure. Now, in Portugal, before a Portuguese court, there is no question but that a Portuguese court will have to give effect both to Decision A, the reorganization measure, and to Decision B, notwithstanding that it wasn't a reorganization measure, because it was Portuguese law. Come to England, come to a court in this country. We know that the English court has to give effect to reorganization measures, and it has to give effect to provisions of Portuguese law which implement reorganization measures. Now, the English court, faced with the same Decision A and Decision B, will have to give effect to Decision A because it's a reorganization measure. It will not give effect to Decision B unless it can be said that Decision B is a Portuguese law implementing Decision A. In other words, the indirect route of giving effect to Decision B, even though it isn't a reorganization measure.
Or ancillary to Decision A.
Well,
Why does it just have to be implementing?
Well, it has to come within Article 3. That's why. It has to be giving effect to, and I use implementing as a way of expressing the giving effect to idea. When you say ancillary, you get very close to doing what the Court of Appeal did, which is to say it's very closely connected to, and for that reason you have to give effect to it. And I'll come on and deal with that.
Well, you're saying a bit more than that. You're not just saying it has a similar subject matter, very closely connected. You're saying it's ancillary to, in the sense that it is part of a legislative scheme which enables among other things, the effect of the August decision to be conclusively determined whether or not that's what the August decision actually said.
If what my lord is doing is putting to me a different way of describing a provision of Portuguese law which gives effect to or implements the August decision, we accept that you would have to then give it effect.
Yeah.
The question is whether the December decision did involve the exercise of a power to implement or give effect to the August decision. And that's where the dispute between the parties arises, and that's where the issue of the expert evidence arises. Can I...
If it had been the other way around, if it had been a transfer of or a declaration that certain liabilities had been transferred, then that would be a completely different position. You would have to accept that that was either itself a reorganisation measure or part of the original one, wouldn't you?
well, you say part of the original one. There's an issue
Well,
about
giving effect to the original one, they just hadn't handed enough over to the new bank. If the reason for taking it out of the new bank was that they felt that they'd overloaded the new bank and had prejudiced its solvency because it didn't have enough funding, then that would be part of the implementing the August decision, would it?
Well, with respect to, it's not clear that it would be. Can I invite the court to...
Wouldn't it be with making sure it worked? The August decision was to sanitise the situation and create a good bank which could deal with the regular loans, and if they decided they'd overloaded it and should reverse that...
Again, there is a risk that one confuses decisions which have effect in Portuguese law
Yes.
and decisions which are part of the Portuguese law way by which the resolution decision is given effect. Can I please invite the court to... I will come to this. I'm slightly concerned that we have three arguments in relation to issue 2. I can win on any one of them. I don't want to take up all my time arguing about the second of them.
Right.
And I have promised Mr. Lord that I will finish by 3. So I still, latest, he says, so I have to get through the guaranteed trust point as well as these other reorganisation measures. But I will come back to this. I'm not running away from it. I just want to make sure I get through other things as well. Okay, so we were talking about, I think I was saying that on the face of it, I was submitting that on the face of it, the December decision is not a decision to retransfer. It is effectively the Bank of Portugal stating what it considers the factual position to be. And I made the point, as Mr. Justice Hamlin said, at paragraph 96.9, in circumstances where what the bank was doing here was making a determination so far as it went that there was no transfer to begin with, which is what it was doing, as Mr. Justice Hamlin said at paragraph 96.9, that was the antithesis of a transfer. It was saying there was no transfer to begin with. I said as a second point that the fact that there was no transfer reflects the position that Bank of Portugal has taken in Portugal itself. Can I just very quickly invite the court to turn up what the Bank of Portugal has said in its defence in the Portuguese proceedings, because there are proceedings in Portugal. It's the Appendix Part 2, Volume 3. At page 3821.
Sorry, page?
3821.
Cool.
It begins at page 3820. At 3820, you can see that it's the BDP defence. And if you go over to 3821, the third point, middle of the page, Bank of Portugal did not determine any retransfer on the 22nd of December, limiting to confirm the application of the specific case rule, whatever. I don't think one needs to be concerned about that. And again at 3845.137, paragraph 137, no retransfer of liabilities, says Bank of Portugal, by virtue of the decision was verified from the information presented, as no transfer occurred as a result of the resolution measure. So again, it's effectively as I suggested earlier, it was effectively making a determination so far as it went that there wasn't a transfer to begin with, no retransfer. Novo Banco's position in Portugal is the same. In the same volume, if I can invite you to go to 3807, which is behind tab
Sorry, 38.
807, I'm sorry. Paragraph 52, 3807. Contrary to the arguments of the complainants, Bank of Portugal's resolution of 22nd December did not enact any retransference of the obligations, merely confirmed such obligations were still in the legal sphere of BES. And we say that, as they say in Portugal, that is in fact the position. And it is perhaps a little bit curious that whilst this is what they've been saying to the Portuguese court, to this court they say something different. So that's the decision and what they themselves have said. I also said as a third point that this is reflected, our position that there was no retransfer is reflected in the expert evidence before the court. Can I just give the court the references to that? Our expert in GSI's, Goldman Sachs' expert, both said the due diligence, the December decision was not a transfer. This is Professor Duarte in his first report at paragraph 6.2.1, core volume 4, tab 40, page 1007.
What?
1007.
Yeah.
Professor Almeida, first report, paragraph 26, subparagraph 1, core volume 4, tab 38, page 970. And at no point did Novo Banco's expert, Professor Moreira, say in terms that the December decision was a transfer. Indeed, he identified 4 or 5 different possible characterizations, but retransfer was not one of them. And for the court's note, Moreira 2, paragraphs 11.1 to 11.4, core volume 4, tab 37, page 953 to 954. Now, the court will have picked up that there are 3 arguments which are made by my learned friends as to why, notwithstanding what the decision says, notwithstanding what they say in Portugal, notwithstanding the experts, they say there should be a transfer. The first point which is made is the suggestion that if you look at paragraph C of the December decision, so back at page 483, that's the paragraph which says Novo Banco and Banco Espírito Santo are to adjust their accounting records to this resolution and act in accordance with what is ordered herein. And it is said that that constitutes in some way a retransfer. With respect, as the majority in the Court of Appeal held, that is clearly not the case. The simple answer to this point is that the direction about the accounts was made to ensure conformity with BDP's view as to what had already happened, not to now affect a retransfer, which was completely inconsistent with the view, with the BDP view of the position. And there is, with respect, a tail wagging the dog element to BDP's analysis here. Accounts should reflect reality, not create it. And that's what the Bank of Portugal in this decision were seeking to do. They were saying, on their view of the fact that the oak liability had not been transferred, they wanted the accounts to reflect that. The fact that the accounts were changed was not in any way, we respectfully submit, a transfer. Now, the second argument, which is advanced in relation to the retransfer gateway, is Mr. Salter's point, which is that Article 47B, he says, doesn't make any sense, because if the court will recall, the argument goes, Article 47B provides a power to retransfer where something that shouldn't have been transferred was transferred. And Mr. Salter says that doesn't make sense because if it shouldn't have been transferred, it wasn't transferred in the first place. Therefore, he says, you have to give Article 47B and the word transfer a meaning which it would not ordinarily possess in the English language. It means something other than transfer or retransfer. With respect to Mr. Salter, that is a bad argument, as Mr. Justice Hamlin found. It is perfectly possible that you could have transferred something which shouldn't have been transferred. Take the situation in which, in addition to transferring all liabilities falling within a particular category, the decision to transfer specifically identifies assets A or liabilities A, B, and C. So it says transfer the following liabilities within this category, including in particular liabilities A, B, C, and D. Now, it's perfectly possible to see how in that situation liabilities A, B, C, and D would have been transferred even though they should not have been regarded as falling within that category. And so with respect, Mr. Salter is wrong to say that Article 47 doesn't make sense and that you therefore have to ignore the ordinary language that is being used there. Now, a third argument that is advanced by Mr. Salter, effectively, this is at paragraph 110 of his case, he says, in effect, in the same way that you have to give effect to transfers and retransfers, you also have to give effect to what he calls untransfers or non-transfers. I'm going to let Mr. Salter develop that argument because it's difficult to know what to make of it. There's nothing in the, unless one is taking a position which says ignore the language, just look at the purpose of the resolution authority or just look at the end results, and this was an untransfer, you have to give effect to it. I just, with respect, don't understand the argument. So I'm going to let Mr. Salter tell your Lordship and your Ladyship what it was about. That is all I think I was going to say about the transfer gateway. We have an alternative point in our written case to the effect that if it was a purported transfer, then it was one in relation to which the Article 47A conditions were not met. That's the need to state specifically the particular shares which were going to be retransferred. Given the time, I don't propose to develop that on my feet. I'm content for the court to rely on...
given the fact that linguistically not supported by a number of the versions and...
Well, with respect, with respect, I don't want to take up time on that, but that is not a reason why I'm not taking. We've put additional official language versions, properly translated, not just the home job, but we've got official translations of these other languages, which we'll put in your bundle, and you will find that it is not unsupported by the other languages.
Just give me...
Supplemental volume, tabs 1 to 4.
Supplemental volume, tabs 1 to 4.
Tabs 1 to 4. But as I say, I just do not have time to develop.
Right.
But those are the other translations. That leaves the pool...
Is that a...
It's the very fat volume. Maybe the court doesn't have it.
Yes, here we are. Yes, thank you very much. Right.
I'm going to move on, if I can, to the tool power gateway. Again, for the court's note, we deal with this at paragraph 47 and onwards. Core volume 1, tab 9, page 191. And so we're on, the question here is whether this can be, whether the December decision can be either a resolution tool, the use of a resolution tool, or a resolution power. Now, I've shown the court the definitions in the EBRD for resolution power. I've made the point that Mr. Salter accepts, or he has accepted, that he cannot get into any of the resolution powers. And I've also made...
Sorry,
he doesn't...
I'm having a
so
little
sorry.
bit of difficulty hearing. It may be that the mic's not in the right place.
Does that help?
Thank you very much.
Will that help? Yeah, I'm so sorry. I've made the point that Mr. Salter doesn't identify... Mr. Salter accepts that none of the resolution powers which are identified is a power that he can say the December decision comes into. His case is that that's a minimum toolbox or toolkit, and that it's up to the Portuguese authorities, if they want to identify further resolution powers, they could have done so. The problem with his case on resolution powers is he doesn't identify any additional resolution power that he says that Portuguese lawmakers provided to the Bank of Portugal. So simply saying that it's a minimum toolkit and that further resolution powers could have been granted to the Bank of Portugal really gets him nowhere in circumstances where he hasn't been able to identify that legislation which gives a further resolution power to the Bank of Portugal. In any event, we say that it is wrong to regard the directive as simply identifying minimum resolution powers, and that we have to recognise any additional resolution powers that any particular state decides to grant to their resolution authorities. bear in mind that this is a harmonisation directive. There is a reference in a case called Kepler to the fact that certainty is important. This is a paragraph 113 of Kepler. Certainty is important, particularly because it is a harmonisation directive. The idea that you can, outside of the four corners of the directive, be producing further resolution powers, apparently not even set out in the Portuguese law, on which you're relying, with respect, in our respectful submission, is misconceived, at least the idea that we have to recognise those as a matter of English law. So far as the resolution tool point is concerned, again, the only possible resolution tool that could conceivably be in play is the bridge resolution tool. That's the one identified at Article 36. Now that involves setting up a new bank, transferring assets and liabilities to the new bank, and retransferring where you want to, or transferring on where you need to, those same assets or liabilities. Again, if this was not a transfer, it's difficult to see how it could be said that this was the Portuguese bank utilising that resolution tool. And again, we're just talking about the December decision. Now, can I just very quickly then show the Court of Appeal decision on this? That's in Core Bundle Volume 2, behind tab 14. It's paragraph 34, which you will find at page 394. Sorry, the relevant paragraph begins at page 408, I'm sorry. If you start just going back at page 408, paragraph 32, was the December decision a reorganisation measure? The court at paragraph 32 identifies the arguments that were made about it being a reorganisation measure, and sets out the argument that I was submitting and Mr. Howard's argument. And then at the bottom of paragraph 32 and going on to 33, the court then deals with the Kotnik decision. The substance of the Court of Appeal's reasoning is all in paragraph 34 on what I've been calling issue 1. And if I can just pick it up about 5 lines down. In the present case, the argument is more difficult than in Kotnik, however, because there does not appear to have been any intention to maintain BES as a going concern in the long term. The December decision was no more than one element in a process leading to its orderly winding up. However, it is accepted that the August decision was a reorganisation measure, if only by virtue of it being a resolution measure, and it is clear that an important part of its purpose was to stabilise the position of BES pending its winding up. The December decision purported to clarify the effect of the August decision and was therefore very closely connected to it. In those circumstances, I think that the December decision is to be regarded as, or part of, a reorganisation measure and is entitled to universal recognition under the Reorganisation Directive. In my view, to hold otherwise would undermine the scheme of universal recognition of measures taken by the home member state to deal with failing financial institutions, which is fundamental to the scheme of European law in this field. And if I can just very quickly make certain observations about this. The first point is that it's not clear which gateway Lord Justice Moerbik had in mind in relation to the August decision, let alone the December decision. If it is thought, or if he thought, if the court thought, that the December decision was intended to preserve or restore BES's financial situation, that never was common ground and indeed is wrong. As I've already explained, the August decision only comes within the reorganisation measure definition by virtue of being a transfer. But whatever basis he considered the August decision to be a resolution measure, it's not easy to see why this should mean that the later separate measure, the December decision, should also qualify as a resolution measure. The reason that Lord Justice Moerbik identifies as to why he was content to treat the December decision as also being a reorganisation measure was, as you see, about 6 lines up, because it was very closely connected to the August decision. But with respect, whether a decision is closely or even very closely connected to another, has no bearing on whether either decision is a reorganisation measure. The fact that it is closely connected tells you nothing about whether that second decision is a reorganisation measure. The court sees that no authority is cited for this very close connection test. And indeed, not only is no authority cited by the Court of Appeal for this, but nor do my learned friends suggest that they can identify any authority which says that there should be a test of very close connection, which should be sufficient to enable a decision to be treated as a reorganisation measure. So not only, secondly, there is nothing in the directive that would justify this very close connection test. Third, and related to that, such a test to determine whether something can be a resolution measure would be positively inconsistent with the mutual recognition scheme, which goes to some trouble to expressly set out such measures which are reorganisation measures. It either is or isn't a reorganisation measure. It can be as closely connected as you like, but if you don't come within the definition of a reorganisation measure, you get no prize. Fourth, and relating to this, the test of very close connection is, with respect, both vague and imprecise. And we say it is therefore inappropriate in a mutual recognition context. And this is a point which I've already made, is emphasised in the Kotnik decision by the Court of Justice, which emphasises the importance of legal certainty. That's at paragraph 113 of Kotnik. And fifth, to have such a test, in our respectful submission, would enable resolution authorities to circumvent safeguards. They have a resolution measure which is entitled to recognition. They then produce a series of measures which are not resolution measures, but which they say are, which are very closely connected, even though they don't come within the directive. And it is said that notwithstanding that they don't actually come within the directive, you have to give them effect because they're very closely connected. That is, in our respectful submission, a recipe for uncertainty and confusion. You see also, the court sees also that the Lord Justice Moerbeck says, I think the December decision is to be regarded as or as part of the reorganisation measure. With respect to Lord Justice Moerbeck, again, this was a question of expert evidence. Can you regard the December decision as part of the August decision? And that was a proposition that was originally advanced by Novo Banco before Mr. Justice Hamlin in the evidence, but they chose not to pursue this proposition that it to be regarded as part of the August decision when that met opposition from the other experts who said you cannot treat this as part of the first decision. And for the court's note, the position in relation to the experts on this is dealt with very fully in the Goldman Sachs case appendix, paragraphs 5 to 9. That's Core Volume 1, tab 10, pages 273 to 275. And so for those reasons, we say the December decision is not within any of the three gateways. And if that is right, then subject to issue 2, which I'm going to come on to, it would follow that Novo Banco, having become a party to the jurisdiction agreement in August, remained a party in December, at least so far as the English court is concerned. And if that is the position, this appeal should be allowed. Again, that is all subject to issue 2. And indeed subject to an argument we advanced about the relevant date, but I suspect I'm not going to have time to develop that, but you have that in our written submissions. Can I just begin on issue 2? And I'm sorry to do this to you just before the short adjournment, but I am running a little bit behind my schedule. We deal with issue 2 in our written case from paragraph 69 onwards, or volume 1, tab 9, page 207. Again, so the court understands this issue arises on the basis that Novo Banco and Bank of Portugal cannot establish that the December decision is entitled to recognition in English law as a reorganisation measure, as defined in the 2004 regulations. So this is an attempt by Novo Banco and Bank of Portugal to have the English law recognise the December decision by an indirect means. Now, can I just identify quickly how the issue arises before turning to the detail of the analysis? We accept, as I've said, that the August decision is a reorganisation measure. And being a reorganisation measure, we accept that the English court must give effect to the August decision, and it must give it the effect that it has under Portuguese law. And that follows from Article 3 of the reorganisation measure. The dispute under Article 3 is about what effect the August decision actually has under Portuguese law. And I make that point at the outset because it is no part of our case that the English court need not give the August decision the effect that it has under Portuguese law. Rather, our case is simply that it does not have under Portuguese law the effect for which my learned friends contend. And the starting point for consideration of this issue, again, is that on the basis of the factual evidence before the English court in this dispute, it is not disputed that if the English court had been asked to decide this question at any time between the 3rd of August and the 22nd of December, it would have found that the effect of the August decision, as a matter of Portuguese law, was that the oak liability had been transferred to Novo Banco. For the court's note, that is set out in Mr. Justice Hamlin's decision, paragraphs 87 to 89. As I say, that is a finding which hasn't been challenged. Now, the question is whether the December decision changes that answer, even on the footing that it is not a reorganisation measure in its own right. In the Court of Appeal, the argument that was introduced at a late stage by Banco of Portugal, not by Novo Banco, was that the December decision does change the answer to what effect the August decision has in Portuguese law, because, so it was said, the December decision, this is the way it was put, the December decision is binding on its addressees until set aside, and it provides the answer to what effect the August decision has in Portuguese law, which is that, as a matter of Portuguese law, the oak liability was not transferred. And so, just using the language that Mr. Howard used in running this successfully before the Court of Appeal, he said, while the question of what effect does the August decision have under Portuguese law was at large, is the expression he used, was at large before 22nd of December, it was, to borrow Mr. Howard's terminology, no longer at large after the 22nd of December, because Bank of Portugal answered that question, and that answer in the December decision, he said, is binding on the parties to whom it is addressed. And it may be, can I just show you what the Court of Appeal made of it, and then I'll stop. Paragraph 28. Core Bundle, Volume 2, Tab 14, page 407.
Well, it's, in different words, the same sort of point.
Beg your pardon?
In different words, it's the same sort of point, isn't it? As Mr. Howard's argument.
Indeed. Effectively, they say, as a result of the December decision, the August decision had a more limited effect in Portuguese law than might otherwise have been supposed.
It's a sort of imposed estoppel.
It's an imposed estoppel, and that's the curiosity here, because, with respect, we say that there were three reasons why this is wrong. The first is they assumed that the December decision constituted and represented Portuguese law, the Portuguese law effect, even though on the evidence before the English court, it is likely that that is going to be overruled. Can I come back to that after the short adjournment?
We'll look forward to that at 2:00.